and welcome to today's installment of the AIAC Diversity in Arbitration Week 2021, organized in collaboration with Racial Equality for Arbitration Lawyers, REAL. My name is Teoh Shu Ling, and I'm a case counsel at the Asian International Arbitration Center. Today, I, alongside my fellow co-interviewer, Dr. Crina Baltag, have the privilege of interviewing the tri-qualified and current head of the international arbitration practice at Frasers Law Company, Ho Chi Minh City, Vietnam, Ms. Earl J. Rivera-Dolera. I'm actually very excited for this interview because Earl's accomplishments are truly inspiring for a lot of young lawyers out there in Asia, including myself. On that note, I would like to introduce my co-interviewer, Dr. Crina Baltag, who is not only a REAL co-chair, but is also a senior lecturer in international arbitration at Stockholm University and a qualified attorney at law since 2004, with an extensive practice in international commercial and investment arbitration, international dispute resolution, private and public international law. Crina has also been appointed in numerous arbitrations as sole arbitrator and co-arbitrator under the rules of the ICC, LCIA, SIAC, FAI, and CCIR Romania. Welcome, Dr. Crina. I would now like to introduce our interviewee, Ms. Earl J. Rivera-Dolera. Prior to relocating to Vietnam, Earl has been based off Singapore of 11 years and has since been appointed as arbitrator in cases with various seats of arbitration, including India, Singapore, Philippines, Hong Kong, Indonesia, amongst others. She is listed as arbitrator at the KCAB, Korea, JCAA, Japan, SIAC, Singapore, AIAC, Malaysia, HKIAC, Hong Kong, CAAI, Hong Kong, Taiwan, and PHAC, Thailand, and is a fellow of the Chartered Institute of Arbitrators and Singapore Institute of Arbitrators. She has also acted and has been appointed as Tribunal Secretary in arbitral proceedings seated in Asia, Africa, Europe, United States, and Australia. She has been involved in various capacities in more than 170 arbitral proceedings in the Singapore-based arbitration chambers with prominent international arbitrators. She is also a co-author of the book Healthbury Laws of Singapore Arbitrations and has spoken at international conferences and arbitration training programs in Asia and the US. Welcome, Earl. It is our absolute pleasure to have you with us today. I would like to hand over to Dr. Crina to start off with our first question. Over to you, Crina.
Thank you very much. Thank you, Shu Ling. Thank you, everybody, for the kind invitation and for the privilege to co-interviewing Earl. And I'm not saying this just from our excellent collaboration with REAL, but also, as mentioned, Earl is a true inspiration for all of us. And I'm really pleased to be with you today. We could hear what an interesting journey you had, or you still have, Earl. And the first question is, what inspired you to pursue this career, in particular a career in arbitration? And maybe summarize in few words how you would describe this journey up to today.
First of all, again, thank you, AIAC, for having me. Thanks so much, Shu Ling and team. And of course, to have someone like Dr. Crina Baltag to interview me is such an honor. She's not only one of our highly esteemed colleagues at the REAL, the Racial Equality for Arbitration Lawyers, but she's in it by herself. You know, I would have been the one to interview her. So thanks so much, Crina, for doing this. As to your first question, I would describe my journey according to just one word. It was a journey of love. Because I didn't have any arbitration experience at all when I first moved to Singapore, and a lot of you may know that I moved to Singapore because of my husband. So after we got married, I moved to Singapore not knowing, what I would do. I was a qualified lawyer already at the Philippines at that time, and I was doing primarily court litigation. So when I moved to Singapore, I couldn't do court litigation, not being a Singapore qualified lawyer. So I studied again at the National University of Singapore, and that's how I got into courses on international commercial and arbitration. And again, I fell in love with it. I think if all my courses there, I focus on international commercial arbitration alone, I think, and got the top marks and caught the attention of my professor, who then became my boss and who opened the doors of opportunity for me in arbitration after that course. And that's how my arbitration journey started.
Thank you, Earl. Wow, it was an intriguing journey. And I'm sure, audience has been inspired by your story and, your successful career in experience. Now, my second question is that, how did you go about forging a career in arbitration in Asia?
Key word there would be preparation. Preparation is a key. When I first got into arbitration, I just devoured whatever I can to learn more about the area of practice. First of all, it was so attractive because at the time, I did not need to be qualified in Singapore in order to be able to practice international arbitration. So it was a good opportunity for me. But of course, not many opportunities come as you are in your early stages of your career. So I took a lot of courses, further courses to hone my hard skills, my technical knowledge on arbitration, and then preparing again, not just on hard skills, but also on finding the right mentors. There will be a lot of mentors out there, but having the right mentors who will generously guide you as you navigate your way into this area of practice is also key. And taking in as much as you can when the opportunity knocks. So being surrounded by all these arbitrators that I had the pleasure, the privilege of working with for the past 11 years in Singapore. And in a way, when you work with them, you get to pick some pieces of their brain, hopefully. And that helped me a lot when I began to have arbitrator appointments, knowing how my boss or this arbitrator would think about these issues. So that really helped me a lot.
This is very interesting because it is a journey. I think you omitted some of the points, the fact that you studied on different continents and you're qualified with different bars around the world. And also the fact that you obviously acted in arbitrations involving different set of rules and different jurisdictions. And I think, and related to the topic of our discussion, I think this diversity, I would say in some way in arbitration has impacted you to some extent. And maybe related to this topic, the question would be, what does racial equality in arbitration mean to you as an arbitration lawyer, thinking of all this interesting journeys in your life?
First of all, I think I would speak for a majority of arbitration users, substantial competence, technical knowledge, and the level of quality of international and cross-border experience, still the number one factor being checked by clients in appointing arbitration counsel or appointing arbitrators. And that's okay. The question now lies where, if all things are equal, everyone has, the same substantial and level of the quality of experience. And on an anecdotal basis, just based on my experience, majority of the clients in arbitrations, especially in Asia, would still be inclined to choose arbitration counsel or arbitrator who has substantial experience in Europe or the US, save for the unique lot of Singaporean arbitrators being a class on their own. But racial equality still is gaining traction for the past 5 years. There's still a long way to go. But especially for Asian legal counsel acting as lead counsel in arbitrations, it's gaining traction for the past 5 years. 10 years ago, when I first started, I wouldn't see, for example, Korean law firms acting as lead counsel. They're the ones bringing in the client, but they would usually collaborate with a law firm in London or in New York. And these are for cases seated in Singapore. But then about 5 years ago, you would see Korean law firms acting as lead counsel already, despite the fact that the arbitration is seated in Singapore and is governed by Singapore law. So, I mean, that's been the trend. And I hope that would translate to arbitrator appointments as well, not just for Asian arbitrators, but for also Asian female arbitrators. I hope to see more racial equality in that.
Now, I believe everyone has experience, when it comes to matter of race and in respect of, racial equality in international arbitrations. Now, to be a successful arbitrator, one has to go through, and overcome many hurdles, I believe. Have you experienced any hurdles in your career due to being a person of, ethnicity? And what sort of situation have you encountered, and how do you overcome this?
Yes, of course, but I wouldn't dwell into too much details, or else we will not finish in time. But there will be hurdles, just as you would have, or anyone would have, being a part of, a minority group. In any industry, not just in international arbitration, but perhaps more magnified in international arbitration practice, because international arbitration practice did not start at all in Asia. So this phase is not the usual phase of an arbitration practitioner, right? So it takes quite some time for arbitration users to get used to the fact that there are now more Asian lead counsels or Asian arbitrators. So there will be hurdles as you try to prove yourself that you're just as competent and as as a person of integrity to be able to handle these arbitration cases. Perhaps the greatest hurdle there would be, the perceived, to me, it's just really perceived, different levels of expertise and competence based on race alone. And I'm not saying this is the perception of anyone, maybe perhaps a few sectors in the international arbitration practice. I wish I could have hard data to back that up, but again, still nothing concrete that could be done on all these perceived perception, just a perception of the different levels of expertise just based on race alone. There is also one thing that I would wish to highlight, what we call as microaggressions. And I didn't know about this until I got into the US and studied in the US about microaggressions. And there are indeed direct and indirect microaggressions against minority arbitrators. One example that I could give you was based on my own personal experience when I had a challenge to my arbitrator appointment. I was already appointed by the arbitral institution, and one of the parties challenged my appointment based on expertise without dwelling or without delving into more details. Of course, it wasn't appropriate to dwell into, ethnicity or race or what have you. Then I found out that the person who replaced me in that appointment. Again, nothing against that arbitrator, who's a good friend, was someone who has less experience than I have. So I Googled my way out and checked the party or the profile of the party challenging my appointment. Someone who's way, way, way older than I am, maybe 20 years older than I am, and graduated in a top law school in the West. So in my mind, it's like, okay, he or she might not be comfortable arguing his or her case in front of me. So, okay, let's just leave it at that. One way to just carry is just to go against or go over all these hurdles or obstacles is just to carry on and to block the noise. To me, these are all just noise and distractions. and just not to take things personally. There will be other cases, there will be other opportunities. If you are not welcomed in this area, then go for the other area. Again, there will be windows. If a door closes, there will be windows that would open, or go to the back door. You know, there's just so many other ways to go over those hurdles. And one more thing that I wish to highlight, I do not adhere to this marketing ploy of fake it till you make it. Just a lot of people, maybe, you know, just marketing themselves as experts without any substantial expertise and competence in the area of practice. Some will make it, maybe at the initial stages, but whether they will last for the long term remains to be seen. As you could see from your senior prominent international arbitrators now, they did the work, you know, when they were still starting early in their stages. You know, a lot of these prominent international arbitrators traveled just anywhere, wrote their way out, published a lot, and then, you know, just became experts in their field. The market will know if you're just faking it. Eventually, they will know, you know, no matter how brilliant your marketing strategy is.
Earl, just going back to something that you mentioned earlier, and obviously the story and the stories that you have probably would relate to this intersectionality. The fact that one is, let's say, a woman and coming from a minority group, does it make it more difficult? Do you think that those who would be in this category would have to fight a double fight? What are your views on this? Obviously, we have in our community different organizations that are trying to tackle one way or the other these issues, but is there anything else we can do? Your views would be greatly appreciated.
Thanks, Crina. I think for a lot of us to keep this conversation going, to keep this dialogue going is one huge step. And the next big step is for educators like Dr. Crina or anyone who are in a position to educate the younger generation to help inculcate a change of mindset. Sometimes the diversity and inclusion issues, especially I could speak for more from an Asian perspective, is arguably a still deep-seated colonial mentality in our psyche, including myself. You know, I still find myself, whenever I would have to choose between an Asian arbitrator or counsel or someone with substantial experience in Europe and US, I would find myself, okay, maybe this person is better, you know, the one from Europe or the one from US. Then I find myself just, okay, stop first and then check my biases. And I guess because of what I have experienced already. But for the future generation and the younger generation, those who are starting in their international arbitration careers, it would have to be really a drastic change of mindset and knowing that the future is going to be more diverse and more inclusive.
Thank you, Earl. Now, I believe that, you have assisted arbitral tribunals in numerous jurisdictions in arbitral proceedings when you were a tribunal secretary. I believe you may have encountered a lot of cross-cultural communication issues in many instances. Could you describe a few of the cross-cultural communication issues you have encountered in your practice?
Sure. I wouldn't say there's any cross-cultural communication issue that would be bound to be damaging to a certain case. I don't think it goes into that level. But perhaps more on instances where something is lost in translation, especially if you have counsels from various jurisdictions, arbitrators from various jurisdictions who are not necessarily experts in one common language. Like one example, for example, the concept of settlement in other jurisdictions, when they refer to settlement, it covers everything: settlement in court, settlement in arbitration, settlement in mediation. But for some other jurisdictions, settlement is just amicable settlement outside of the courts, outside of the arbitration system. That's one thing. And also the concept of objections. For a lot of common law lawyers from various common law jurisdictions, we're so familiar with objecting at the hearings whenever there's a misleading question and all that. But for some jurisdictions, especially civil law jurisdictions, the concept of objection may sound foreign to some and may even sound rude. So I was a bit scolded on that when I was involved in a civil law governed arbitration, when one counsel informed me not to use objection, but to use like request for clarification or something like that. So, so as not to be rude, to sound rude to the arbitrators. So that was, a good point of learning for me.
Going or from the communication or how this diverse languages and cultures in arbitration meet. My question would go to the tribunal, because obviously we have you're mentioning with the appointing Asian arbitrators. Now that we went a step further and we have lead counsel coming from the jurisdiction maybe of the client, and we want to see this representation with the arbitral tribunal. Do you start experiencing more diverse tribunals, and do you believe that it should reflect the users of the arbitration, of that particular arbitration? And if not, what can we do about it? Of course, from the perspective of counsel, but also from the perspective of an arbitrator who would like to be more appointed in international arbitrations.
Yes, great question. 10 years ago, I wouldn't say it was diverse. Slowly, we are getting there, getting more diverse appointments in terms of race, but not yet in terms of gender, I must say. Still goes a long way. Again, we still have a long way to go on diversity in that respect. I would say that I would highlight the importance of the role of the chair or presiding arbitrator. If you have a 3-member tribunal, because eventually the chair or the presiding arbitrator must be nimble enough to just navigate his or her way into having both co-arbitrators meet, having their minds meet, and having also the counsel's way of communicating meet as well. And if there would be any disputes, that arbitrator would be able to resolve the disputed issues in terms of communications or communicating style. So someone, a chair or presiding arbitrator who could navigate nimbly all these communication issues, and someone who would avoid and who knows how and when to avoid racist remarks and or remarks that could be perceived as demeaning to a certain race or nationality, and then someone of that race or nationality may be, one of the counsel or one of the arbitrators, and someone who is also who wouldn't wouldn't shy away from from calling out certain co-arbitrators who may have said something racist or something like that. Calling out, privately, of course, not in within public consumption or in front of the hearing, but someone who is, very much in tune with diversity and inclusion issues and would translate that into the hearing or into the way he or she conducts an arbitration hearing.
Now, I understand that, we have many young lawyers out there now in the audience, especially, who are interested in pursuing their legal career in arbitration. And, what advice would you give to any arbitration practitioner who wishes to make their mark in international arbitration in a jurisdiction other than their home jurisdiction?
It all starts with law school, I must say. I know for sure that while still in law school, we wouldn't have any awareness yet or knowledge yet of what we want to specialize in while we are in law school. But, just on major 2 skill sets that would be highly valuable in the practice of international arbitration that I would wish to highlight, law students or early stage practitioners would want to improve on. It's really the writing legal argumentation, and advocacy, oral advocacy skills, which would be really highly valuable when you enter into international arbitration. And the soft skill of perhaps being adaptable, easily adaptable. You know, your training may be under maybe perhaps, let's say, Malaysian law or Singapore law or Philippine law or European law. But then you might be asked or you might be instructed by client that, okay, you will be arbitrating under Korean law, you know, because you have this Korean client who's investing in Europe and all that. So, you know, just to be being adaptable and who would easily have this relentless drive to learn something new and not be afraid about it. I would also, you know, advise, you know, early stage international arbitration practitioners to keep a detective mind always. You know, I would really, I mean, when I would be working with my team, I want someone, associates or even senior associates, who have this relentless drive to pursue the right evidence, know where to look for it, because your witnesses or your client might not know what evidence might be relevant or material. But if you have this mindset that, okay, let's look for all these other evidence and then get it from the clients, then again, just that relentless drive to pursue what is good for the case of your client.
That's excellent advice. I subscribe to this, and I hope everybody would hear and take notes of this. How just adding to this, perhaps, and you mentioned when somebody finds herself in a situation of maybe discrimination or bias, then just let the world be, and you continue on your way. But adding to your advice to the young practitioners at the start of their career, when they're facing the situations, any other advice that is maybe putting them in a more proactive position? Would you think that that would be appropriate? And if so, what would be that advice or those steps to take?
Thanks, Crina. First of all, we have to accept that biases will always be there. Perhaps in my lifetime, not just at anyone's early stage of one's career. It will always be there. You cannot please everyone. I guess that wisdom comes with age as well. I have come to accept biases and rejections are redirections. Redirections to what would be more appropriate for your skill set. And I have come to accept that rejections, biases are also protections. Protections from that opportunity, which may not be a good fit for you in the long term. And then you just find yourself appreciating what you have now based on the rejections that you have had in the past. It will always be part of life, rejections and biases, because again, you cannot please everybody. Just don't take things personally. There's bound to be something else for you, and that would be a better fit for your skill set.
Thank you, Earl, for your sharing and advices. Now, come to our last questions. What are your thoughts actually on initiative such as the AIAC Diversity in Arbitration Week in promoting racial and cultural diversity in international arbitrations?
Thanks, Shu Ling. And I'm not just saying this because AIAC is hosting this, but kudos, congratulations. We've had a lot of talk and dialogue about diversity, but it's usually just for an hour or two. But AIAC has considered and focused a whole week just talking about diversity and inclusion. And congratulations to AIAC on that. And I hope more and more arbitral institutions or organizations like, for example, the CIRB and all that would go into delving more into this topic in the future. So great initiative. And of course, working and collaborating with REAL is a substantial step, especially with the clout of REAL, spanning the globe and not just Asia. And just to keep this dialogue open for now and not to make it die down its natural death. I hope not. To keep the dialogue open and in the future, perhaps short term or long term, I do not know, there will be concrete steps and more arbitral institutions and arbitration users will listen, so long as we keep the noise going, keep the dialogue open, and more will be opening up to these issues and take concrete steps in their arbitration rules or arbitration law. And then there will come a time we won't have to talk anymore about diversity and inclusion.
If I may add to Earl's words, and with many thanks for such an insightful conversation today, I would like to personally thank AIAC for organizing this and allowing REAL to be a partner in this dialogue. And I agree that raising awareness, continuing the dialogue, it's the right thing to do. And I'm sure that with these small steps, we're going to make bigger steps in the future. So I would add my appreciation and thanks to AIAC for this.
Thank you, Crina. Thank you, Earl. Thank you for sharing your insight, advices, and input. I would like to thank REAL for collaborating with the AIAC, and I would like to thank my co-interviewer, Crina, and also especially Earl. It has been a pleasure to have all of you on today's sessions. To our audiences, thank you for tuning in. With that, thank you and have a good evening.